thank you all for participating. We're good morning, Dan and Patrick and Timothy. So thank you so much for that. Good morning. I'm going to kick it off to Patrick. And Patrick and Tim are both from LRB Thompson, and as most of you should know, LRB Thompson has had a long history of providing helpline services for GMA. Again, there is a helpline for ACCG, so if you're with ACCG, we can provide that information to you also. But with that said, take it away, Tim, or take it away, Patrick.
All right, Dan, thank you very much, and good morning, everybody. This is an update on COVID-19 and local government issues. So we're going to discuss the general guidance that sometimes makes its way into the newspapers, but also some of the constitutional issues that don't make their way into the newspapers. And we gave this presentation originally, as you'll see on the cover screen, July 27th, and this is kind of the encore presentation. Between then and now, some of the contents have changed because the guidance has changed, the landscape has changed in terms of COVID prevalence and the need to take additional precautions and things like that. What we're presenting today, as we always want to clarify, is training, not legal advice. Legal advice needs to be based on individual circumstances, and we're not able to get into that level of detail today, but we're providing you what is now current information. But as we were sort of joking with Dan before inviting everybody into the stream this morning, this is current as of today. By tomorrow, it may not be. And that's just sort of the nature of COVID guidance. Some of the stuff I think is fairly static at this point, but again, we've made some updates even since about a month ago when we first presented. As you'll see on the second slide in front of you now, our roadmap generally is to talk about vaccine policies, mandatory versus encouraging, and some of that, the feel of that of mandating vaccines has changed since the first presentation even. We'll deal with the issues of requesting proof and kind of what you can and can't do and how you have to handle it if you do. We'll talk about the treatment of vaccinated versus unvaccinated employees in terms of both, just getting information, but also return to office consideration. That those second two kind of the second and third main bullet points kind of blend together as we go through this. So to get started with this agenda, I'll turn it back over to Tim, who will talk with us about some of the mandating vaccine policies.
Yeah, thanks so much, Patrick. So as Patrick kind of said, some things have changed since the last time, since about a month ago when we gave the earlier version of this presentation. Obviously, things change by the day, by the hour, so we try to stay ahead of it. One thing that has not seemingly changed is that some of the legal and constitutional and statutory considerations for mandatory vaccine policies, we believe that some of the discussion that we had and some of the key analysis that we think would go into a court analyzing whether it would uphold mandatory vaccine policies, we think that has likely been kind of confirmed by the very limited cases that we've seen so far. There's always a chance that courts see it differently. However, some things that we have seen have kind of made us felt that some of the ways that we are analyzing some of these issues do seem to be correct. One of the big things that has changed in the meantime, and you might have seen it, is that Indiana University had a vaccine mandate. We can talk a little bit about what exactly that mandate involved, but that mandate was challenged by some students and some faculty, and it was the vaccine mandate was upheld by the trial court, at least on a preliminary injunction standard. The Seventh Circuit, which kind of covers that area of the country, upheld it, and then the Supreme Court decided not to review the issue, which is essentially saying, that it not explicitly saying that it's correct, but it may not be something that they're willing to overturn some of the rulings that upheld those vaccine mandates. So a lot of the analysis that we have seen from that case is one of the few that has kind of worked its way very, very quickly through the courts. Some of the analysis and some of the legal issues that were raised in that one are kind of consistent with what we have been seeing and how we've been analyzing things. Now, some of the big things to keep in mind, there's a lot of legal theories and constitutional theories that have been thrown out when we're talking about possibly mandated vaccines. You've probably seen a lot just in conversation. You've probably seen a lot in the news, things like that. From our perspective, the biggest things that we see from a legal and a statutory side is one, ensuring that employers meet their obligations under the Americans with Disabilities Act. And two, meeting their obligations with respect to Title VII, and specifically the requirement to reasonably accommodate sincerely held religious beliefs. From a constitutional side, the biggest things that we're seeing is under the Due Process Clause, dealing with some liberty interests that are implicated by mandatory vaccines, and second, the Free Exercise of Religion Clause. So we can go through each of those in turn. So under the ADA prohibits employers from making disability-related inquiries or medical examinations unless they are job-related and consistent with business necessity. Generally, a disability-related inquiry or medical exam of an employee is job-related and consistent with business necessity when the employer has a reasonable belief based on objective evidence that an employee's ability to perform essential job functions will be impaired by a medical condition, or that the employee will pose a direct threat due to a medical condition. Now, direct threat with respect to the ADA means that there's a significant risk of substantial harm even with a reasonable accommodation. One thing that we have seen in some of the recent guidance from the EEOC is that they have confirmed that COVID-19 meets that direct threat standard. So that means that that if an employee were to have an employee with COVID-19, they would pose a significant risk of substantial harm to themselves or others in the workplace. So if an employer is considering doing a mandatory vaccine, under the ADA, the obligation is that you have to provide reasonable accommodation for those who have a disability. And with respect to a mandatory vaccine in particular, we believe that that would require an employer to exempt any employee who, because of a disability, is unable to be vaccinated. We have seen some disabilities, some medical conditions that do not allow employees to be vaccinated, or the vaccination may not necessarily allow, they may not be allowed to be vaccinated, or it may not help them in the same way. And so they, under that instance, they may request an exemption from the vaccine mandate. And so in that situation, a reasonable accommodation may be allowing that, would likely be allowing that employee to be exempted from the vaccine mandate. So in considering those exemption requests, what that requires the employer to do is provide an interactive process to determine whether a reasonable accommodation exists. That interactive process is going to be a discussion between the employer and the employee focused on whether the impairment is a disability and the reasons that an accommodation is needed. This review process should be confidential, and it should apply consistent standards for medical exemptions such as requiring a doctor's note that kind of gives information as to confirms the existence of an underlying disability and the relevant medical contraindications. The reasons why the employee cannot take the vaccine because of that underlying disability. Now, in that conversation between the employer and the employee, focused on identifying a reasonable accommodation, there are certain accommodations that we think could be reasonable depending on the situation. Now, the thing about the confidential interactive process is that it's very fact-driven. So what works for some positions, what works for some employees may not work for others. So some of the things that may be that are likely to be reasonable accommodations in a lot of situations are, whether that employee, instead of in being exempt from the vaccine mandate, are they able to work remotely so that they're still removed from the workplace so that they're not a direct threat? Is their work able to be done outside of regular business hours so that there's less interaction with some of the other employees, some of the other individuals in the workplace? Could it be an extended leave of absence? Maybe there's a situation where because that they have some sort of medical condition that doesn't allow them to be vaccinated right now, but they may be able to be vaccinated given a passage of time later on. Now, it's, as I said, this is an individualized assessment regarding both cost and burdensomeness to the employer to try to identify what a reasonable accommodation would be. Some of the things that we have been seeing, and in that Indiana University case, one of the things, and Patrick will talk about, we'll talk about this a little bit later in the presentation, is that some of the things that we have been seeing is that instead of a vaccinate or terminate, which is you either assuming you have the necessary exemptions for disability and religious beliefs, requiring employees that don't have an exemption on those grounds, requiring them to be vaccinated or face termination. One thing that we've been seeing that's a bit of a step down from that is requiring vaccination or that an employee submit to weekly testing and universal masking all of the time. That's something that could be a reasonable accommodation as well. If that employee's position, if the workplace actually allows that, the consistent testing and masking to actually eliminate that direct threat of COVID in the workplace from that employee. Similar to the Americans with Disabilities Act, Title VII of the Civil Rights Act, and specifically the portion of Title VII that relates to religion, prohibits workplace discrimination in terms of conditions of employment on the basis of religion. Similar to the ADA, a policy has to be job-related and consistent with business necessity. So what we believe is that under, and the EEOC has confirmed this in some of their recent guidance, is that you have to exempt an employee who, because of a sincerely held religious belief, is unable or unwilling to be vaccinated. Once again, you have to provide, similar as we talked about before with the ADA, have to provide for the interactive process to determine whether a reasonable accommodation exists. A lot of times in this reasonable accommodation process, in the confidential process, a lot of the similar kind of reasonable accommodations may be there for those that are exempted on religious grounds as well. Working remotely, working outside of regular business hours, possibly having a leave of absence. Although if someone's, that's the leave of absence is probably less likely to be a reasonable accommodation in this situation, because whatever their religious belief is now, that's probably not going to change after a short leave of absence. Nonetheless, there are some situations where that may arise and could be a reasonable accommodation. We talked about the undue hardship standard under the Americans with Disabilities Act. For the undue hardship for Title VII with respect to religion, the standard is much lower than under the ADA. So under Title VII, it's just more than a de minimis cost, decreased productivity, showing that a reasonable accommodation, showing that an accommodation would be an undue hardship to an employer is much lower under Title VII than it is the ADA. As a general rule, some of the mistakes that we do see under religious exemptions for Title VII is that sometimes employers or supervisors, the persons that are actually taking in the exemption requests, kind of look on the exemption, maybe don't believe that it's necessarily a sincerely held belief. As a general rule, the safest bet is just to assume that the request for a religious exemption is based on a sincerely held religious belief. However, the employer can request additional information if you have an objective basis for questioning the factual basis for the requested exemption, either the religious belief or whether it's sincerely held by that actual employee. Now, getting into the constitutional considerations, what we're mainly talking about here is the Due Process Clause. The Due Process Clause deals with property and liberty interests. The liberty interests here with respect to mandatory vaccine are the interests in bodily integrity and the right to make decisions about medical treatment that could be implicated by these mandatory vaccine policies. By way of background, the Due Process Clause has two different components, a procedural component and a substantive component. Procedure, as the name suggests, the procedural component deals with just the process utilized. So the employee has to have notice and an opportunity, notice and hearing. Under the substantive portion, then that more deals with the state employer, the local government employer, will have to meet a certain justification for an interference into that liberty interest or property interest. What we're dealing more with here is with vaccine mandates is substantive due process. So under substantive due process, you'll have to show that the mandatory vaccine policy is supported by a compelling government interest. And you have to show that the policy is narrowly tailored to accomplish those goals without unnecessarily interfering with that liberty interest, with the bodily integrity or right to make medical decisions about your own body. What that second portion deals with is that there must be no alternative means available that would be equally effective in achieving the policy's objectives while infringing less on that liberty interest. So before we get into the free exercise clause, when we're talking about, one of the things that has happened in the past month, as I said, the Indiana University vaccine mandate that was challenged in court that the Supreme Court decided not to take up. So essentially left the vaccine mandate in place. That one found that protecting students, staff, and faculty, and controlling the COVID-19 pandemic on the university's premises was a compelling government interest. So we think that similarly, it would be a compelling government interest for a local government to want to stem the spread of COVID-19 on its own property and to stop the spread from going from its own employees and staff. The last big kind of constitutional consideration that we believe may be implicated by mandatory vaccine policies is the free exercise of religion clause. The Supreme Court's held that the free exercise clause of the First Amendment prohibits government interference with religious beliefs and, within certain limits, religious practice. To satisfy, we think that most mandatory vaccines will likely satisfy the free exercise of religion clause with how we presume they will be drafted. To satisfy the free exercise clause, the policy has to be neutral on its face and in its origin. Can't be instituted, just to attack certain religions, certain religious beliefs. And it has to be of general application. It has to apply to all of an employer's, all of a local government's employees. Regardless of religious motivation of prohibited conduct, and not specifically directed at religious practices. Now, the free exercise of religion clause, even though they both deal with religious beliefs, the free exercise of religion clause and Title VII dealing with religious beliefs, they both deal with religious beliefs. However, the free exercise of religion clause does not have an accommodation obligation. So technically your obligations under Title VII with respect to that portion of any policy, it is greater, because under Title VII, as we discussed, you'll have to make reasonable accommodations for those that ask for an exemption from the mandate for sincerely held religious beliefs. So some drafting and implementation tips for some of these mandatory vaccine policies is one, you'll want to say in the policy itself that the policy is adopted for the purpose of promoting public health and safety by protecting employees, residents, and community at large from the spread of COVID-19. Policy should be of general application, facially neutral, not adopted for the purpose of disadvantaging any person or class of persons due to disabilities, religious beliefs, practices, or any other protected status or activity. The policy should be narrowly tailored to accomplish those health and safety related goals and remain job related and consistent with business necessity, while still giving due consideration to whether there are less burdensome means by which the goals can be accomplished. You also want to make sure that you include that the policy expressly allows employees with disability and or religious-based objections to the mandatory vaccine to request exemptions, and provides for a confidential review process by which such requests can be meaningfully evaluated. Now, in terms of confidential, we're really talking about only including those employees that have that are involved in on a need-to-know basis. So, HR, possibly the immediate supervisor, but really most times you're not going to need to involve coworkers, people in other departments, things like that. Just keeping it to those that need to know. The policy should also provide or allow the local government employer to engage in an interactive process with each employee exempted from the vaccine requirement for the purpose of attempting to identify a reasonable accommodation that would enable the employee to perform his or her essential job functions without posing a threat to the health and safety of either himself or herself or coworkers, or impose an undue hardship on the employer and its operations. So one of the things that you could be talking about with undue hardship, we talked previously about, possibly if it's the type of position, if the employee works in the type of position that can be moved remotely, if the employee could be given different hours, something like that. Some of those may be an undue hardship on the local government, extending hours, things like that, just to allow the employee to work, outside of the normal business hours, to cut down on interactions with coworkers and customers, things like that. It may be an undue hardship in certain situations. You also want to make sure that the policy is applied and enforced uniformly with regard to all employees. And lastly, you want to make sure that you're giving consistent training to supervisors and department heads so that so that they are aware of what the employer's policies are, and also so that if any employee comes to them with any sort of disability or religious-based objection, then they can appropriately deal with or appropriately route that objection to the right person. One thing to add to in terms of training is that once you're, a lot of these policies, even employers that we've helped with put into place these policies, even as we talk about with this presentation, some of the information has changed in the last month. Well, your policy is going to have to probably be revised as circumstances change. So that training should be up, there should be training to give any updates on the policies to supervisors and department heads. Talked real quick about different types of policies. What we are really envisioning when we talk about a mandatory vaccine policy is either assuming the exemptions are provided for under religious beliefs and disabilities, either employees that are not exempt under those two grounds, they either have to vaccinate or they will be terminated. Well, a different policy that we've been seeing, and the federal government has started some of this. I think Biden announced it shortly after our last presentation, is that some of them are dealing with a vaccinator test type policy. So under that, we're more talking about either you vaccinate or you submit to consistent testing and all the time masking if you're not willing to be vaccinated. That we kind of see that as a tier below the vaccinator terminate type policy. Because of that, we think that those will hold up under the constitutional concerns, assuming all of the things that we discussed before are met in terms of exemptions. But those types of policies, the vaccinator test, bring up some other issues in and of themselves. So one, we believe that the employer is going to be likely to be responsible for the cost of testing. And second, we also believe that the employer is going to have to compensate those employees for the time they spend testing. Under the Fair Labor Standards Act, the employer is required to pay employees for time spent waiting for and receiving medical attention either at their direction or on the premises during normal working hours. So the reason that we think that that the employees will probably have to be compensated for this time is because most employers, because it's either vaccinate or test, the test is going to be an integral and indispensable, will be integral and indispensable to that employee's work during the pandemic. Another thing that you may deal with is what if an employee coming onto the work site requests an alternative method of screening due to a medical condition or a religious belief. So for example, they ask to be exempted or given a different type of testing than that's currently done for COVID-19. Technically, that's a reasonable accommodation as well, and the employer should proceed as it would with any other type of request for accommodation under the ADA or Title VII. If the EEOC has said that if the requested change is easy to provide and inexpensive, the employer might want to go ahead and choose to make it available to anyone who asks without going through the interactive process. But you may have to go through the interactive process in that if the disability is not obvious or known, or the employer feels like they need additional information to establish what the condition or disability, if the condition is a disability, and what specific limitations require that accommodation. So you may need that information to figure out what exactly is a reasonable accommodation to the screening that's currently done, the testing. So those are kind of the things to keep in mind if employers want to go towards the vaccinate or test method. Now, for this next portion, moving away from kind of mandatory, Patrick is going to speak a little bit about encouraging vaccinations kind of in the workplace.
Thank you, Tim. And this is one of those places where the program has changed, because the first bullet point of this slide back in our late July presentation said this: recent survey, 80% of employers are not planning to require vaccines. And right before that program, the Veterans Administration had come out and said it was going to require vaccines, at least of certain workers in the organization. And I had a note that this 80% number might change. Well, now we're presenting it as there's been an updated survey that says 46% of employers now are more strongly considering a mandate in light of the Delta variant. And so my question for you is, do you remember June? June was great. I was fully vaccinated. A lot of my clients were fully vaccinated. I scheduled lunch meetings in restaurants, and we took our mask off and ate together inside. But then the Delta variant picked up, and I checked yesterday on, I think it was the federal HHS website that kind of tracks some of the numbers commensurate with the CDC's information. And the region that has the southeastern states shows that due to the Delta variant, hospitalizations now are higher than they were back in January, which was the supposed peak of old original COVID. So because Delta has gotten worse, and I think a lot of us mentally in June thought, oh, good, we're through this. The worst is over. And now we're going to be able to do stuff again and not have to wear those balloon masks, and it's going to be great. And for June, it was great. And then July came, and it was like, well, I don't know. Maybe I'm not quite so comfortable meeting people inside anymore. And then we got into August, and now I'm wearing my mask again a lot. So I think because of that, and because it was either, I think it was August 23rd, I'm looking at another screen here, that the FDA gave full approval to the Pfizer vaccine. So that kind of took away some people's reticence to insist on a vaccine mandate, because the previous vaccines had only had the emergency use authorization. But with the FDA approval, more people, I think, are considering mandating this kind of the vaccines. But now we're kind of shifting gears between the mandate versus encouraging. And the question really is, what is the process for getting information about somebody's vaccine or vaccination status before you give them whatever you're encouraging them with, and how much can you encourage them? And this slide gives a pretty good overview that if you've got an employer-administered vaccination program, your reward, your encouragement, can't be so substantial as to be coercive. The reason for that is that if it's employer-administered, you're the one asking those pre-vaccine questions about somebody's health status. And you're going to learn some things as part of that questionnaire, and that is ADA covered information. So if you're getting that information, some of the restrictions as to this amounts to a mini wellness plan, then you can't do something that's so substantial that people would feel they can't turn down the opportunity to reveal their disability information in exchange for a brand new car, if you were offering that. So that's why the offer has to be much smaller if it's an employer-administered program. If it's a third-party provided program, then those limitations don't apply. So if you're just saying, show me your vaccine card from your doctor or from a clinic or wherever, a drive-through, that doesn't implicate it, because you're not collecting the information that would make this trigger as a mini wellness plan. So Tim, if you go down to the next slide. This slide shows some examples of what employers are offering in terms of encouragement or inducement as part of a vaccine program. Some of our clients have done an extra day of paid time off. Some of them have done gift cards. I think all of those things have been fine and have not been challenged. So I think we're a little bit saying we think it's fine because it's not been challenged, and we think it fits within the regulatory guidelines. but you'll see various examples of what you can do. For a while there, early in the year, the EEOC came out with temporary guidance that said it needs to be de minimis. Well, that's not very much. And the examples given were a small dollar amount, like a $10 gift card or a mug or a water bottle. Well, that's not going to persuade anybody. So I think that guidance was since withdrawn. So that is off the table. And again, we're just kind of left with it can't be coercive. But this is the list of things that can generally be provided and that would seem to work with respect to encouraging vaccinations. And then the question arises, how am I going to encourage if I don't know that somebody's been vaccinated? So Tim, if you'll go down to this next slide. Now we're going to consider requesting proof of vaccination and how you can handle that information and kind of the guidelines for taking care of that. So in requesting proof of vaccination, we've got some legal and statutory issues that we'll cover, mostly from the federal EEO laws. We'll talk for a little bit about HIPAA and also a state executive order on vaccine passports. The constitutional stuff that Tim has already discussed, those things apply here too, in that you're asking for information that can be viewed as private to an individual. But I'll let Tim's coverage of that kind of suffice here in the interest of time. So if you go to the next slide, Tim. Yeah. So the EEOC guidance that's out there about vaccine issues permits employers to request proof of vaccination status. It doesn't violate the ADA because of the interest that Tim identified before, that this is viewed to be, the pandemic is viewed to be a direct threat to the health and safety of folks. So it doesn't violate the ADA, doesn't violate Title VII. Again, as long as you provide those ways out if people want to discuss accommodation, and it doesn't implicate GINA because you're not asking for genetic information going back. So all of that allows the EEOC to say, you're good as far as we're concerned. But in that second bullet point, you've got to keep that information confidential pursuant to the ADA. So what that means is don't put it in the personnel file, retain it, somewhere else. And the ADA standard of confidentiality is you can only share it with those who have a need to know. So I'm going to use my hands here and say HR can have everybody's vaccine information. Yes, I'm vaccinated. No, I'm not. They've got the whole list. Then if you've got a department director, that department director can get everybody's vaccine information for everybody who reports to that director. So if this is the public works director, and over here there's a police department director, the public works director is only getting information about the people that report up to the public works director, not the folks over in police. So then under the department director, again, if you're going to enforce some of this information in terms of if somebody is not vaccinated, we're going to require them to wear a mask, you might need to share who's who. So under the department director, if you've got a manager, the manager only gets information about the people that report to that manager, not everybody in public works, just to that manager. So it's kind of a cascading approach of how much information you can share for purposes of enforcing city or county policy with respect to mask wearing or other restrictions that may exist in distinguishing between vaccinated and unvaccinated. That last point about warning employees not to provide medical or genetic information as part of their proof, there are a couple approaches to make sure that you do this. If you do it electronically or through an app, I like the use of radio buttons where you can only click yes or no. That makes it very easy, and they can click yes, I'm fully vaccinated, or no, I'm not, and then that's it. There's no other opportunity to provide information. If you do it verbally, what I suggest is that you preface your questions with, I only need a yes or no, are you vaccinated? Or without telling me why, are you vaccinated? And that way you're not getting information that somebody might want to share that, oh, I can't be vaccinated because of my X condition. You don't want to know what their medical condition is because that raises ADA implications. So you can kind of preface that sort of thing with those questions. If you'll go, Tim, to the next slide. In the last program, we just kind of addressed this verbally, but since we're going to circulate this one, we put in a couple of slides about HIPAA. HIPAA does not apply to these requests by an employer for somebody's vaccination card. I'll give you a very quick primer and one story on HIPAA. The privacy rule says that you can't have protected health information handled in a careless way by covered entities. But covered entities, as you see listed there, are health plans, healthcare clearinghouses, basically information centers that take healthcare information and distribute it around, mainly working for insurance companies and certain healthcare providers. And you'll see at the bottom, employers, as long as they don't fall into one of those other categories for what they do, are not covered. So HIPAA is not implicated by these vaccine requests. And Tim, if you go to the next one. So this makes clear that HIPAA doesn't restrict an employer from asking for information, but HIPAA does restrict a covered entity from providing that information. So the example is you couldn't ask an employee's doctor about the employee's vaccine status without an employee's authorization. You could ask the employee, but if you were to ask the doctor, that would take a HIPAA authorization. And my quick story is, years ago with a private sector employer in Middle Georgia, we were dealing with an employee issue where drug use was involved, and the employer just wrote a letter to the employee's doctor, no HIPAA authorization, no nothing. And the doctor said, well, yeah, he's got these issues with substance abuse, but do you know about his alcoholism? Because that's the real problem. And just laid all this out in a letter. And I thought, guys, you got a lot more information than you should have gotten. But now that we know this, and it was really only a HIPAA problem for the doctor, because the doctor is a covered entity under HIPAA, but the employer's not. So I just share that story to reinforce that it's the medical community and insurance companies generally that have the HIPAA restrictions, but not employers in most circumstances. Yeah, thank you, Tim. You may remember that in May, the governor issued an executive order that you'll see in that first big bullet point there, deals with state agencies, state service providers, and state properties. And you'll see the restrictions there of the may nots. That does only apply to state employees and state entities. So cities and counties are not included. You've got to be at the state agency level or state employee level for that to apply. But looking at the bottom bullet point there, you may hear some of this if you were to have a vaccine mandate or even a vaccine incentive program, because that executive order says that having a vaccine passport program would raise individual liberty issues. So again, if you hear something like that, it may be from this executive order that applies to the state. And one more slide, Tim. This is just a final consideration of do's and don'ts. We've covered, I think, all of the do's there. The don'ts, don't ask follow-up questions. Again, you don't want to get into something where somebody says, well, I can't get a vaccine because I have, this condition. And if you didn't know that before, you know it now. And so every future employment decision is made with the knowledge that somebody has this, underlying medical condition. So you don't want to ask those follow-up questions. And you don't want to share vaccine status without express written authorization, except as I described before, with kind of the cascading of information from department director to manager, only giving each of those leaders information about the employees in that particular person's area of supervision. So with that covered, I'm going to turn it back over to Tim to discuss some return to the office kind of considerations.
Yeah, thanks, Patrick. So obviously in the last month or two, we've seen some shifting in terms of who's getting brought back to the office, what the return to office plans are, and a lot of that is due to Delta kind of changing everyone's plans and showing that maybe we're not quite out of the woods as much as we thought we were. So there's some things that employers should be considering if they're actually deciding to bring people back to the office, similar to, if they're if they're not mandating vaccines, what do you actually do with a workforce full of both a mixed workforce of vaccinated and unvaccinated employees? Well, some things to kind of keep in mind. Unvaccinated employees, the EEOC says that you can't take job-related action unless no reasonable accommodation can eliminate or reduce the risk of adverse consequences without imposing undue hardship on employer. Same thing that we saw before. What that really means is that when you're, a lot of people are dealing with employees that don't want to get vaccinated yet, and also don't want to come back to the office yet because they've been working from home for a long stretch now. Well, the reasonable accommodation may still apply with respect to those employees that have disability or a sincerely held religious belief, getting them back in the office. With respect to vaccinated employees, there's still some things to keep in mind because we've seen some new ADA concerns with respect to those that may have conditions that do not make the vaccines quite as effective as some of those without those disabilities. So some things that employers may have to keep in mind with respect to their ADA responsibilities, even with vaccinated employees. And then we've gotten the new CDC guidance and some of the guidance that has followed from other agencies in the wake of that. So obviously, we talked a little bit about before, the CDC walked back their initial guidance from May for the fully vaccinated. Now there's a lot more steps that fully vaccinated have to account for. Masking indoors in areas of substantial or high transmission, still masking outdoors in certain situations. And then regardless of level of transmission, you may have to wear a mask if the employee is at risk or if someone in the household is at increased risk of severe disease, if not fully vaccinated. And that's even if you're fully vaccinated. And there's still, because we know that fully vaccinated can still carry and transmit, especially the Delta variant, so well, there are new kind of testing guidelines for exposures for those fully vaccinated. OSHA, for those employers that are not requiring vaccines, what steps should you actually be taking with a workforce full of vaccinated and unvaccinated employees? OSHA guidance. This OSHA guidance was just recently issued, and it was issued in the wake of the updated CDC guidance. So as you'll see, it kind of tracks that new CDC guidance on fully vaccinated. For public employers, well, not only is the OSHA guidance just that, it's guidance and doesn't necessarily create new legal obligations. It's also OSHA also is not a legal obligation for local government employers. So some of the OSHA, but OSHA can give good helpful tips for how to deal with both fully vaccinated and unvaccinated folks in the workplace. So some of the OSHA guidance, some of the key things that we were able to pull out of that. Keep physical distancing in communal areas for unvaccinated and at-risk workers. Provide face coverings and surgical masks to employees at no cost. Education and training, especially for managers on COVID policies and procedures. Suggest or require unvaccinated customers, visitors, guests, or others in public-facing workplaces, and all of those customers, visitors, or guests in public indoor settings in areas of substantial or high transmission. Keep up with the routine cleaning and disinfecting. Stagger break times so that there's less commingling. Stagger arrival and departure times if you're able to avoid congregation. Still provide those same visual cues, signs, and everything. Hey, wash your hands for 20 seconds. Use as hot of water as you can when washing your hands. Now, a lot of the CDC guidance, a lot of the OSHA guidance is based on areas of high transmission. So right now, what does that mean? That's just about everybody, and that's the entire state of Georgia for our purposes. So a lot of those things, a lot of the guidance is with those kind of mitigation steps is applicable to a lot of the employers that we're dealing with, and a lot of the employers throughout the country. There's only very small pockets that aren't in high or substantial transmission areas. As I said, there are some new, CDC has issued some information that seems to suggest that there could be new ADA concerns for at-risk individuals that are, even though they are fully vaccinated. As I said, the situation that we're dealing with there is that some conditions, some medical conditions that could be disabilities, that are likely disabilities, may affect a worker's ability to have a full immune response to vaccination. Under the ADA, those at-risk workers could be and are likely entitled to reasonable accommodation, even though they're still vaccinated. So it's important to keep in mind, even though your fully vaccinated employees may still have some accommodation requests, and the employer's obligations under the ADA may require you to enter into the interactive good faith process and possibly make some reasonable accommodations. Now, some of the things that we've dealt with as you're kind of pulling, as employers are pulling people back into the office, some important things to keep in mind as you're dealing with these accommodation requests for people that may be asking to continue to remote work instead of coming back to the office. ADA does not require that an employer accommodate an employee without a disability based on the disability-related needs of a family member or other person with whom they're associated. You're not entitled to, an employee's not entitled to their preferred accommodation, only a reasonable accommodation. Now, as you're kind of going through and dealing with, even though there's no accommodation obligation, if the employee doesn't have a disability, but they have, for example, a family member that has a disability, maybe they live with an at-risk person, there's no accommodation obligation under the ADA. But if you are going to, provide some sort of accommodation to that employee, if you decide to do that, make sure you are being consistent with providing that, so that there's no allegations of disparate treatment on other protected grounds. Second, the EEOC has said explicitly that the fact that employers temporarily excused performance or one or more essential functions when it closed the workplace and allowed employees to telework, or employees otherwise chose to telework, doesn't mean that the employer is permanently locked into having to change that job's essential functions. If telework is no longer a feasible accommodation, or if it imposes an undue hardship, then it may not be a reasonable accommodation anymore. This is going to be fact-specific stuff. A lot of that is going to depend on what type of role the employee is in. If it's a lot of in-person customer service type work, then telework, now that places are opening up, telework is probably not going to work anymore, and probably not going to be a reasonable accommodation. And lastly, kind of, obviously, I think even though they are well-founded, even though they might be well-founded, generalized fears about contracting COVID-19, unless tied to some mental or emotional disability, doesn't require an accommodation. Generalized fear isn't likely going to place an employee in protected status. So just because they don't want to come back to the office because they're afraid they'll catch COVID-19 doesn't necessarily mean that they're entitled to an accommodation. I know I went through that last part pretty quick, but wanted to leave enough time for questions. So happy to answer any that you have right now, or kind of address maybe some other potential issues that you all may be thinking of.
First of all, great job, both of you. We do have one question at this point in time. Since the Pfizer vaccine is now FDA approved, if an employee gets vaccinated as a requirement of their employment, can the employer be held liable if they were to have a bad reaction to the vaccine requiring hospitalization?
We think the answer is no, because the medical part of it is handled by the vaccine provider. So whether it's a doctor's office, a drive-through place, or whatever, that's all supposed to be handled by the place that's administering the vaccine. Most of them make you wait for 15 or 30 minutes or whatever to observe you before anything like that. So again, I think the look at the policy is going to be, was there a valid reason to have it? The EEOC says yes, there's a direct threat because this is a pandemic level issue. And as long as there is an out for people within the policy, as Tim went through, you've got religious exceptions, you've got the disability exception. As long as those are in place and the person had an opportunity to say, hey, I think this condition is going to be problematic, then I don't foresee liability. Now, some creative plaintiff's lawyer out there might come up with some theory, but my sense is that any liability in that regard would rest with the vaccine provider.
Yeah, and there are to kind of add to that, there are some states that and legislatures that have talked about possibly adding some sort of language to allow certain effects from the vaccine to be under workers' comp, but as far as I'm aware of, that hasn't actually occurred yet anywhere, and certainly not in Georgia.
Any other questions? Anybody else have anything they would like to know? Again, we'll be sending out this recording, and Tim and or Patrick, if you could send me your finalized presentation, I will forward that to all those that have registered for this event. Any other questions? Anything else that's burning in your heart that you want to know about? Well, Timothy, Patrick, thank you so much. We really, really, really appreciate your time, and I'm hoping that we won't see a whole lot of changes, but what they say about hope, probably not gonna come true. With that said, thank you all for participating. Thank you both Tim and Patrick for your presentations. Again, as I said before, I will be sending out a link to the recording along with a copy of the presentation to all those that are registered. If you have any questions, please do not hesitate to send me an email or call me. Thank you both. We will let everyone go. Talk to you later.
Thank you, Dan, and thanks everyone for coming out.